Morning. If you would please rise and join me for the Pledge of Allegiance. The United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And with that, I will open our first public hearing of the day and invite the sponsor of HB 1158 to introduce the bill.
All right. Well, thank you to my friends on House Criminal Justice and Public Safety. For the record, I'm Representative Joe Alexander. I represent the town of Goffstown. I'm here to introduce HB 1158. I filed this in collaboration with the Grafton County Attorney, who is here today to answer more technical attorney-related questions. So, as I am not, I'm punting. I may punt some questions to her. But basically, this bill provides a clear and necessary clarification to New Hampshire's domestic violence statutes by clearly defining intimate partner to include both sexual and romantic relationships. So the current law can be ambiguous when relationships do not fit a narrow and outdated definition, creating uncertainty for prosecutors, law enforcement, and the courts. This has real world consequences. So delays in issuing protective orders, complications in charging decisions, and barriers for victims seeking immediate relief and safety. So it basically aligns the statute with reality. So they're important. These changes are important because the domestic violence victims who are in a consensually sexual but non-romantic relationship with their abusers, aka friends with benefit, would qualify now with this increased definition. Is like maybe you're not in a romantic relationship, but you do have some sort of sexual arrangement.
Isn't that what you kids call a situationship?
A situationship. Yeah. I don't know, but yes, that's what we call that. So so I just wanted to put this in. I think it's a really effective change to our current law just to include that because there are real world consequences. And as somebody who's had to file a protective order before and got granted a protective order, I just think like any delay in issuing these can be really critical. It's probably the hardest thing I've ever done in my life. So I just think like this is a necessary change to current law. And I hope you support it.
Thank you. I have a question. What jumped out at me right away is sexual relationship. Again, I have to go by what I hear my kids say, but in today's hookup culture, is a one night stand considered a sexual relationship?
Yes.
So someone that someone meets at a bar one time, sleeps with, is now entitled to get an order against that person forever? I mean,
well, protective orders generally only last a year.
no, I mean, they could go like 2 years from now and say, for example, if they see that person with another person and they get mad and they're like, you know what, and they could go get an order. Is that possible?
Protective orders aren't issued like that. So let me
and understand, I know how they're issued because I've actually been there when they were issued, but I understand what you mean. But if they have made a credible story, it will be issued. That's my only concern is, do we maybe need to define sexual relationship with a little, and I'll ask the attorney because I'm sure.
Well, so and Mr. Chair, thank you for the question. I would say like when you have, to follow your lead, you meet a girl at the bar, you guys go home, you just have a sexual relationship for one night, girl gets crazy, comes after you, starts stalking you, sends you messages. Technically, under the current law, you wouldn't necessarily qualify because you only had a sexual relationship. Nothing was romantic about that one night stand, but you did in fact have one.
I'm very romantic, but okay, yeah.
You're a romantic guy. Some of us aren't. So
go ahead.
Boy, this is going in the wrong direction.
Hey, we got to have fun where we can.
This is a great bill to start with.
All the better that it's at the hands of Representative Alexander. So. In the stalking circumstance, does that qualify under? I haven't read the domestic violence statute recently, but that one night stand, the individual starts stalking you, does that qualify under the domestic violence statute, the stalking piece to it?
So as far as I know, just from experience, there's two sort of protective orders you can get: domestic violence and stalking. So I'm not a lawyer again, so I'll probably punt this question, but I would assume yes.
Okay. Thank you.
Representative Lascelles.
Thank you for taking my question. The way I read this, there doesn't have to be a sexual relationship, right?
Yes. Well, I mean,
Because it says whether or not such relationship was ever sexually consummated. So,
I guess that
well,
would
that's
follow
the
the
current law
romantic
too.
part.
I mean,
So-
the current law says romantic relationship, regardless of if it's sexually consummated. All I'm doing is adding in sexual relationship.
Those are two separate pieces of
Yeah.
the same law. Yeah.
Just to add to this, I think what should be done, speaking as a lawyer, it should read, or in a romantic relationship in which you should, that clause that says no such relationship was ever sexually consummated should be written better to refer only to romantic relationship. It just, that needs some rewriting.
Yeah. Still need to hear from the county attorney because I'm not necessarily sold on the, yeah. Okay, thank you. No further questions.
All
You're
right.
good.
Thank you so much.
The chair calls Marcy Honright. Good morning.
Silver, red. Okay, thank you. Good morning, everyone, and thanks for having me. Professor Schur, I'm a lawyer who did not have you as a professor. I apologize.
There's actually one?
Yeah, sorry.
But she was a public defender at one point.
True, true. To go back to one of the questions, we've run into a situation, or a couple of situations, which is why we were looking to have this amended, in which there was a sexual relationship between a couple of people. One of the parties, it was not romantic. I mean, there was obviously some romantic overlay, I guess, but one of the parties didn't want to continue with that relationship, and the other party did and pushed it and pursued it. This wasn't a one-night stand. This was an ongoing thing, perhaps a month or longer. When it went too far, we were looking for a way to help the victim with charges out of the domestic violence statute, but because it was not considered a romantic relationship by either of them, essentially, it couldn't fit into the domestic violence statute. So therefore, when we created the charges and when the defendant was ultimately charged, a criminal bail protective order could not be issued because it was not covered under the DV statute, and therefore relinquishment of firearms did not come into play. I'm sorry to speak in negatives, but that's the protection we're looking for essentially, is to get to the ability to have the firearms relinquished with a criminal bail protective order. We've seen these types of situations too frequently where victims of essentially domestic violence don't have that immediate protection, and problems occur after the fact. So we're looking for the rewrite. We like it to be as clear as you all, as we think it is, because again, this does cover sort of a natural evolution of times and reality and relationships that we're seeing, as I say, an increase of in our office in the criminal justice realm.
Thank you. I guess,
One last thing, I'm sorry.
Sure, go ahead.
Sorry to apologize. You mentioned stalking. So separately, a person in that situation or scenario that I've just discussed could go get a stalking order, out of the civil court, but the criminal process does not protect that person.
would the stalking order, though, allow for the relinquishment of firearms?
Not necessarily, but yes, certainly, that could be part of it.
And also, As part of a bail order, does the judge not have the power to order all basically the same things as though it were a protective order?
Sure.
Stay
sure.
away from the victim, no firearms?
Yes, absolutely. But the criminal bail protective order and the DV statute, just provide some extra immediate protections.
Yeah.
It has a sort of overlay, again, I'll use that word, where there's some immediate concerns for the protection of the victim.
I agree. Agree, and I understand that. My only concern that remains is the is the ability from just a one night stand for someone to obtain an order that controls so much of another person's life based on a one time encounter. At that point, are we not just extending it to everybody then?
Well, we see those anyway.
Yeah.
The reverberations from one night stands when
Yeah.
youthful decisions are made, sort of exacerbated by alcohol use or other, stimulants. So we see that anyway,
Yeah.
separate and apart from this.
Yeah.
This is a bit of a nuanced area,
Yeah.
which is not, we're not looking necessarily at the one night stands because, as I say, we see enough of those.
Yeah.
We do have 2 colleges in our county,
Yeah.
so we're dealing with that pretty frequently as well.
Okay. Representative Scheer.
Thank you. Two things. First, would this read better if it read in the or in a romantic relationship, whether or not such romantic relationship was ever sexually consummated? Would
I'm
that-
sorry, say that one more time.
In a romantic relationship, whether or not such romantic relationship was ever sexually consummated, that would take care of Representative Lascelles' problem. That is, the way it reads now, it suggests that the such relationship never needed to have been sexually consummated, which is kind of silly.
That's the original bill, yep.
Yeah, so I would just add the word romantic, such romantic relationship rather than such relationship.
I'm not sure that gets us there.
Why not?
Because I think, I almost think that such further confuses or muddies the water.
Well, the such is already in there.
Yes,
So I'm just putting the word romantic, I'm just making that dependent, to speak too much like a school marm, I'm making that dependent clause dependent solely on the term romantic relationship rather than also dependent on the term sexual relationship.
Otherwise, it makes no sense for the sexual part because you can't say involved in a sexual relationship whether or not sex occurred. You have to separate those two, it seems to me.
so intimate partner means a person with whom, this is the proposed
Yeah.
bill language, with whom the actor is currently or was formerly involved in a sexual relationship, comma,
Yeah.
or in a romantic relationship, comma, whether, regardless of whether or not the relationship was sexually consummated.
Yeah, and read that way,
Take the comma out, actually.
well,
it with a
it's just
semicolon.
easier to just put the word romantic in referring to the relationship in lines 4 and lines 9. Just put the word romantic and it's abundantly clear. We don't need to figure out what the dependent clause refers to. It's obvious.
Yeah. We can hash that out during the executive.
Follow up.
Yeah.
Second area of questions. Am I correct in understanding just because someone had a one-time sexual relationship in this new proposal with an individual, they don't get a domestic violence protective order? They've got to meet the other criteria of the domestic violence statute, right?
Right.
Representative Prue.
So, just a question for my clarification overall. I take a woman to lunch 2 times. Am I in a romantic relationship?
That's between you and that woman.
So it's, okay, so there's a little bit more than just 2 dates that makes that relationship. You have to have that mindset, yes?
Yes.
Okay, thanks.
Yeah. Thank you.
And follow up on that. So, but that's for the judge to determine what is and what is not a romantic relationship. on, or do we have a definition in statute?
A romantic relationship?
Yeah, what constitutes a romantic relationship?
Well, that's, yes. I mean, so it's for the investigator to be able to ascertain, but it would also go into how we would consider charging.
Yeah.
So yeah, it would ultimately be up to the judge, I guess, or the jury, if I understand your question correctly.
Yeah. Well, in my defense, for example, in his scenario, I went out with a person 3 times.
3 times.
And that person wants an order, and I say, I was never in a romantic relationship. We only went on 3 dates. Where does one, is there jurisprudence on what a romantic relationship is?
Messy jurisprudence. I think the question, both for the investigator and the charging authority, as well as for the judge, if it gets to that point, is, if one person thought, I don't know why, but if somebody went out with you and on 3 dates and they thought it was by then a romantic relationship, putting aside their judgment, but you didn't, that's something I'm sure the investigator would take into consideration, charging authority would, and if it got to the point there was a charge, that would be up to the judge. There's no hard and fast definition of romantic relationship, or for that matter, whether both parties need to believe there was a romantic relationship, one party and not the other. That's factual determination.
And I want to use this word. Under the new statute, one-time coitus would trigger their ability to get the order.
If the other element, sadly, I'm answering for the witness, but if the elements, the remaining elements of the domestic violence statute were met, which involves threats or actual violence,
At the risk of getting in the weeds here,
we're already there.
in today's environment where people establish relationships online. And in that case, there is maybe it could be considered romantic because they go back and forth, but there's no sexual relation. At some point, one person wants to break it off. Could that be part of this or not?
I don't think so, but possibly. I mean, as you're talking, I'm thinking about people who fall for AI bodies or
Yeah.
whatever we call them. I'm thinking more of stalking, along with what Professor Scher was referring to earlier. But we'd have to examine that more closely to see if it met any other elements of the statute. Again, I suppose we could go there like you in the weeds, but we could come up with all kinds of different scenarios where we would do a what if this, what if that.
Thank you.
We're just trying to line up one very specific area that we've seen actual examples of.
Seeing no further questions, thank you very much.
Thank you all very much.
And I'll probably end up reaching out to you with more questions, but thank you.
Anytime. Thank you.
And Terry,
Just,
I'd like an order.
I'll represent all of you. But to look at the Protective Order Statute 173B3, it reads, any person seeking relief under 173B5 by filing a petition in the county, blah, 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 alleging abuse by the defendant. So it's not just the romantic relationship, even if the judge, there's got to be a finding of abuse as defined in the statute. It's not just because of your relationship with a theoretical chair.
Well, like your incident with Galinda the troll you told me about online, it turned out to be a bot, so that's fine.
Yeah, and there would have to be a finding of an allegation of some sort of abuse, not just a romantic relationship.
No, and I'm hoping they're enjoying it.
I know, I could go on I can
anyone-
pull Representative Alexander into this too, if we want.
Anyone else wish to testify? Seeing none, I hereby close the public hearing. Just so everyone knows, I had no intention of execing anything today, so. And I say that because if anyone needed it to go or whatever, I'm not going to exec anything. I'm opening the public hearing on House Bill 1173 and invite the sponsor to introduce the bill.
Good morning. My name is Buzz Scher. I am a representative of Rockingham District 26, Ward 3 in Portsmouth. I'm also the recently elected chair of the Portsmouth Police Commission and a part-time employee at UNH Law. My testimony today is my own as a representative, and it does not speak for either the University of New Hampshire, UNH Law, or the Portsmouth Police Commission. And this bill, the committee saw this bill last year. At that time, Representative Muse was the prime sponsor. It received unanimous support from this committee. It was on the consent calendar and passed the House, and then it got hijacked for things having nothing to do with this bill in the Senate. It was amended to a version of a completely non-germane amendment, and so the bill disappeared in that process. The Department of Corrections was supportive of this bill. What it does is the Department of Corrections, the state prison, already releases individuals on work release and they have a program that's been around for a long time. And this just adds to that program people who, in preparation for leaving the prison, are trying to get a college degree, a post-secondary degree, either an associate's degree or a bachelor's degree, and allows them to leave the prison to go to classes, residential classes. It doesn't require any additional security or administrative resources beyond what's already being used for the work release program. It just adds this category of people to that. With that, I will more than willing to answer questions.
Seeing none, thank you. Who's next? Anyone else wishing to testify on this bill who wasn't filled out a card? Seeing none, I hereby close the public hearing. Actually, why don't we exec this? We passed it last year. It's the exact same wording, I think. Are you guys okay with this? Yeah. Are you okay with passing this? This bill we just, it's the one we just. I hereby open the executive session on House Bill 1173, and I'm open to any motions.
I move
Representative Scheer.
ought to pass.
Second. No,
I believe Representative Murray got that one. Discussion. I'll just say, we passed the exact same bill last year. And wait a minute, Representative? Yeah.
Mm-hmm.
Nah. Can he do what? He did. Okay. Yeah, it was his motion. We passed this last year, exact same language. And Representative Scheer, do you want to add anything to that? Yeah, I believe you did. With that, will the clerk will call a roll? The motion is ought to pass.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Paquette,
Yes.
Representative Soborn Deschrenier,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Scheer,
Yes.
Chairman Roy,
Chair votes yes.
12-0.
12-0. Any objection to consent? Seeing none, we'll go on consent. I close the executive session. If you could get me that report this week, please.
It was there. It was there.
It's right in front of you. The problem if I did that. I know. I'm already stretching.
Well, you know what? If you took the same amount of bills and scheduled the 15 and space for lunch, because we don't seem to have that ever. Then you could probably get away with it.
Yeah.
Yeah, the long ones. You still end up being the same. Right.
Gerald Evans used to do 10 o'clock, and only 10 o'clock, when all the bills listed. The problem
won't
there
let me
is
do
it's
that.
a pain in the ass for witnesses, so we
Yeah.
didn't want to show up.
Right.
It is.
It would be better though. I mean, we could get through a lot quicker, but the more witnesses.
But especially when we're in different buildings, how would people would be sitting around with never knowing.
Yeah.
It would be easy for us, but not.
Yeah, especially people who travel a long way.
I hate to say it, but
Yeah, yeah.
maybe the,
Because you never
this
know.
chair is better. than
2 hours.
their others.
That's crazy.
And then you have the ability to introduce someplace else, especially when we're in a separate building. Right. Yeah.
I'm opening the public hearing on House Bill 1235. Is that right? No, it's not. 1175. I got a little ahead of myself. And invite the prime sponsor to introduce the bill.
Thank you, Mr. Chair, members of the Criminal Justice Committee. For the record, my name is Representative Joe Alexander. I represent the town of Goffstown. I love saying this seems like a pretty straightforward bill because somebody's going to have a problem with something, but this is a pretty straightforward bill. All this does is update the current RSA to qualify for basically an advancement in crimes that people commit. So it modernizes the fraud statute to reflect how payment credit card technology is actually used. So it's outdated, focuses on magnetic strip technology. As the committee is aware, we rarely use magnetic strips. A lot of it is chip reading. You pay with your chip on your credit card, things like that. So it just closes the gap and provides clear statutory authority to prosecute fraud that involves chip-enabled cards. Again, the Grafton County attorney is here. She had a situation where she was unable to prosecute somebody because they used chip instead of the strip technology. So I just think this closes the gap and it's pretty reasonable, and you should vote for it. Thank you.
Thank you. Representative Scher.
Representative Alexander, could you explain to me in detail what a integrated circuit chip is?
I don't know what that is.
Thank you.
It's probably on a credit card. Yeah, thank you. Was that like a joke or a real question?
Yes, both.
Okay.
Yeah. Seeing no further questions.
Thank you.
And the chair calls County Attorney Honrick.
Good morning again, everyone. Marcy Hornick, Grafton County Attorney. We did run into an issue in Grafton County. We were able to get to a charge, but it wasn't within this statute because the statute did limit us in our ability to move forward out of this particular statute. And the circumstances were pretty interesting in that a person worked in a takeout window and happened to have a little square on his belt. And so when somebody was, when people were driving through and presenting their credit cards to pay for their to-go order, that person in the window was just touching it to his belt. And it was a square thing. I'm not sure what to call it at this particular point, but so the business was being robbed, and that person was making away with customers' money unknowingly. I mean, he was doing it knowingly. The customers didn't know until after the fact. So that's the reason. It's just an update. It's just basically a clarification and amendment.
Thank you. Do we not have other existing like embezzlement or?
Sure, yes.
So would this, or does this statute give you more ability to charge more appropriately than an embezzlement statute or a general fraud statute?
Or
I'm trying to
theft.
figure out why we have so many.
Or theft, yeah.
Yeah.
It does, but without it, it limits us. I mean, it sort of allows somebody to use that and not face the full potential panoply of of statutes that should be, I mean, they should be updated to address the current climate.
I agree. It's just, I was thinking, wait a minute, that sounds like embezzlement. So why wouldn't we be able to just charge them with embezzlement?
As
Is
I
that
say-
not a more serious charge?
Well, as I say, we were able to charge that person, but out of a different
Yeah.
part of the code. But
As long as this is here, it might as well be updated.
exactly.
Yeah, gotcha. Thank you. Further questions? Seeing none, thank you.
Thank you.
Anyone else? Anyone else wishing to testify on this bill who hasn't done so? Seeing none. I hereby open the executive session on House Bill 1175 and make a motion of ought to pass.
Second.
Seconded by Representative Prue. As I was saying, I feel like we have a lot of laws to cover the same thing, but as long as we do have this law, it should at least be updated to modern times. And I think that all cards that are being issued now are coming with these chips. So what the attorney said is probably actually going to become more prevalent as this happens. So I think it's probably a good law. Would you like to speak to your second?
Sure. I agree that it needs to be updated because that's the new technology, and if we're not keeping up with the technology, people will get away with stuff or not get what they deserve. So, our integrated chip that contains all your information to make that transaction, in case you were wondering what that was all about, needs to be updated. Thank you.
Further discussion?
Too bad he wasn't paying attention.
Yeah. Seeing none, I ask I ask the clerk to call the roll. The motion is ought to pass.
Representative Prue,
Yes, please.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
12-0.
Any more objection to consent? Seeing none, it'll go on consent. I close the executive session. Hereby open the public hearing on House Bill 1216 and invite the sponsor to introduce the bill.
Good morning. My name is Buzz Scher. For the record, I represent Rockingham District 26, Ward 3 in Portsmouth. I'm also the chair of the Portsmouth Police Commission and a part-time law professor at UNH Law. What I say today is solely my opinion as a representative. It's not the opinion of UNH Law, or the Portsmouth Police Commission. HB 1216 this bill was filed last year in this committee and passed unanimously, I believe, and went on the consent calendar and got to the Senate. It foundered in the Senate because of concerns about the breadth of the language surrounding the word property. The prior version of this did not use the term real property. It used the term property, and it was the Senate Judiciary Committee felt that that term was too broad and might include the clothes of a suspect that an individual arrested, which was not intended by this. So we changed the language to say a person's home or any other real property. And on page 2, lines 1 through 2, real property is defined as real property means any buildings, structures, and equipment permanently attached or fixed to the land. That's a standard. I didn't make that language up, nor did Representative Roy. That's language, standard language for a definition of real property. I would point out that in spite of what you may hear after my testimony, this bill does not impose a burden of any significant kind on the police. We know that because several sessions ago, a bill was passed, crime sponsor was Representative Roy, that amended RSA 595-A10 to include the motor vehicle language. That is, when a police officer stops a motor vehicle and makes a request to search the motor vehicle, before an individual consents, the police officer must get a signed consent for the search, a signed consent that says, I'm consenting to the search. I understand that I have the constitutional right to decline the search, and there can be no consequences to my exercise of the constitutional right to decline the search. That bill passed the Senate, passed the House, was signed into law. That's been the law as to motor vehicle consent searches for 2, maybe 3 years now. And I've talked with my police department and other police departments, and nobody's had a problem with this because in many, at least the conversations I've had, many police departments had that practice already with consent motor vehicle searches. This bill, and they had no problem with the additional quote unquote paperwork that went with that. In fact, those police departments that have body cams, including state police, a consent recorded on a body cam is enough. It need not be in writing. So this merely expands it to home searches of homes or other real property is defined here. It's not an administrative burden. If the officer's wearing a body cam, that will be enough to get the consent as long as the person is informed that they have a constitutional right not to consent and there's no negative consequences to their refusal to consent. Or the police officer can have them sign that form. It's a simple modification of the form that already exists for motor vehicles. It's just a relatively minor extension. Portsmouth Police Department already has such a form for consent searches of real property. And my belief is a number of other police departments do. So I'm more than willing to entertain questions.
Representative Muse.
Is there anything in this bill that would authorize a non-consensual search of somebody's property?
No, if it's a non-consensual search, then the police, before they do a non-consensual search, need to get a search warrant unless the circumstances meet one of the standard search warrant exceptions. I won't go in detail about there's 4 or 5 search warrant exceptions, exigent circumstances, etc. But if it's a non-consensual search, a search warrant is required subject to it meeting one of the search warrant exceptions.
Representative LaSalle.
Where does probable cause come in?
Probable cause doesn't come into this statute because if somebody, one of the search warrant exceptions is consent. If somebody consents to have their property searched, be it their car or their real property, then the police don't need probable cause. So only if the person does not consent does the police officer then either need a search warrant supported by probable cause, or they need to meet one of the search warrant's exceptions, almost all of which require showing a probable cause.
Is it, the state of the law is that the property can be seized while they are getting a warrant, correct?
Correct.
And the person can be separated from that property so as not to damage or tamper with any possible evidence.
Correct. So if the police go to a house and knock on the door and somebody answers and the person says, they ask for consent to search the house and they don't have a warrant, and the person says, no, you don't have my consent, they say, okay, I'd like you to step outside. And we're going to detain you while we go get a warrant. The warrant process is a lot faster than it used to be. And so they can detain the entity being seized, not allow people to enter or leave while they go get a search warrant.
Thank you. No further questions. The chair calls Pat Sullivan.
Good morning. My name is Patrick Sullivan. I'm the Executive Director of the New Hampshire Association of Chiefs of Police. I am not a member of the Portsmouth Police Commission. Just,
Not yet, anyway.
dear Chairman Roy, members of the committee, as the Executive Director, I here representing the New Hampshire Association of Chiefs of Police. I have 43 years of law enforcement experience, and I'm here to testify in opposition of House Bill 1216. I'm going to hit on a couple high points of my written testimony. Under a long-standing U.S. Supreme Court and New Hampshire Supreme Court precedent, a consent to search must be voluntarily given and free from coercion. If it is not, the court has the jurisdiction to oversee that and not allow that evidence or testimony if it's not freely given. So we're actually creating new laws that we already have in place through court rulings. Officers that shift away from consent-based searches due to procedural demands on this bill likely see an increase in personal property being seized for warrant-based searches. Items like cell phones, backpacks, wallets, clothing, etc. may be held for hours and sometimes days while a warrant is obtained, ultimately undercutting the very protections this bill seeks to protect. It undermines the effectiveness of undercover operations. If an undercover officer goes into a house, does he have to inform them or request consent to search their house while he goes in an undercover capacity? This doesn't address this at all. Will we lose all the evidence within that? Another example I heard, if I knock on a door, I talk to the resident and I want to come in and tell them something, and I walk in and there's marijuana, cocaine, a dead body laying in the floor. And I didn't get written consent. Is that all gone? Because that's what this bill will do. That's all I have. Thank you.
Thank you. The scenario you just gave, where you knocked on a person's door because you wanted to notify them their car was parked in the street, and they said, "Yeah, come on in," and then you were there and you saw it, wouldn't that fall under the Plainview Doctrine at that point?
It absolutely could, but I'm now inside.
But
Okay?
you were invited in. You didn't go in with the intent to search, right?
No, I did not.
Okay. All right, no further. Representative Shear, do you have any questions?
As a technical matter, I don't think I'm allowed to ask questions,
Oh, that's correct. I'm sorry for my parliamentary fox paw.
as much as I would love to.
Yeah, I thought I saw you raise your hand, but you're correct. No further questions. Thank you, Chief.
Thank you.
Anyone else wishing to testify hasn't done so? Seeing none, I hereby close the public hearing. I'm opening the public hearing on House Bill 1235 and invite the prime sponsor to introduce the bill. HB 1235, who is it? Oh.
Oh, wait, no, he didn't. It's all of them.
Solomon?
Sure, it's all of them.
Is that one of your guys?
Yeah.
And when do you want to introduce the bill for? Would one of you guys like to introduce the bill for, this is one of yours?
Thank you, Mr. Chair. My name, I should have a little sign that says this, but,
You don't have to repeat everything you said last time.
okay.
It's on the record for the day.
Thank you. I appreciate that. I am here to introduce on behalf of the prime sponsor, Jared Sullivan. My name is Buzz Schur. House Bill 1235 fiscal note. I haven't thoroughly read the bill as I'm not even a sponsor. Probably doesn't make sense for me to answer questions. I can answer questions if anyone wants to ask me about marijuana, but I'm not sure I can.
Do you know what this bill purports to do?
Excuse me?
Do you know what this bill purports to do, or?
It authorizes the possession and use of cannabis by a person 21 years of age or older, subject to certain quantity restrictions and other limitations. Without reading it, it seems to be a statutory effort
Full
to
legalization.
mirror the constitutional amendment that we heard earlier this week. I think it's CHC 19, if I'm not mistaken, that Representative Wheeler put forward.
Thank you. We appreciate it. And that's fine. I think someone's here that's going to testify more on the bill. We appreciate it. The chair calls Matt Simon.
Thank you, Mr. Chairman. For the record, Matt Simon, Granite Leaf Cannabis. I was preparing supplementary testimony, but I'll take the opportunity to explain a few details about the bill. It's designed to be very simple. It's often been called the Vermont style bill because it resembles the legalization bill that initially passed in Vermont and was signed into law 8 years ago by Governor Phil Scott. Like that bill, it would simply eliminate penalties for personal possession. The amounts in the bill are 2.5 ounces of cannabis flower, 10 grams of concentrate, and up to 2,000 milligrams of, cannabis products other than concentrates, which means edibles, generally containing no more than 2,000 milligrams of THC. So merely eliminating those penalties for personal possession, not creating a regulated market, not creating taxes or anything like that. So for my testimony, so this bill, we support it. It would not benefit the therapeutic cannabis program or the businesses in any way. If anything, we would expect to see a somewhat lower rate of patient registrations if it becomes law. But we are not concerned about that potential outcome. We don't think you should be either. We support HB 1235 simply because we think it's wrong for adults to be fined or arrested for cannabis possession in the live free or die state. So that's Granite Leaf's position, and since that only took me about 30 seconds, I was hoping to use a minute or two to comment on my experiences in Vermont, where they did decide to go down this path. So in my previous job as New England political director for the Marijuana Policy Project, I spent a lot of time in Vermont, specifically working with Vermont Senate Judiciary Committee, which was chaired by Senator Richard Sears. He had a reputation as a hard-nosed, no-nonsense legislator, and he passed away a couple years ago. So I'd like to respectfully dedicate this portion of my testimony to his memory. When I first met Senator Sears in 2012, he did not support legalization or even decriminalization but he did have a clear and consistent set of standards that he applied to legislation. And he had a lot of concerns, similar to the ones we've heard expressed in this committee and others, about the message that Vermont would be sending if it decriminalized or legalized cannabis. What he frequently reminded his committee that I loved was, we are a policy committee, not a messaging committee. At the end of the day, this is a public policy question. Senator Sears had a knack for distilling policy issues down to the essentials, and on this one, he framed it by saying, lots of people are using marijuana. Prohibition hasn't stopped them. So what is the appropriate government response to those facts? 2013, he became convinced that the appropriate government response was not arrests and prosecutions. He championed a bill to replace criminal penalties with civil penalties, and that became law. A few years later, he became convinced that the appropriate government response to cannabis possession was no response. In other words, he decided to support legalization. In that year, Vermont tried to pass a comprehensive legalization bill. We've seen several of those in New Hampshire that have fallen short. Like those, this one failed in 2016 in the Senate. And in that process, we learned that legalization is often presented as a yes or no question. You're either for it or you're against it. But through that process, we realized that there are actually dozens of very important policy questions contained within cannabis regulation. And we were unable to reach consensus in Vermont on those questions, much as we've been unable in New Hampshire. But that's what led Vermont to, in 2018, passing a simple bill that did the one thing everybody agreed on, and legalized simple possession. And in the wake of that, we saw most of the people who had been fighting against it for years came to the table. And over the next few years, we were able to work together and craft a thoughtful, responsible regulatory model. It really took passing that initial simple legalization bill to bring so many of the opponents to the table to discuss next steps. So as you consider HB 1235, I'd like to invite you to consider through the lens provided by the late Senator Richard Sears. Tens of thousands of Granite Staters are using cannabis today. What is the appropriate government response? I hope you'll agree with me and the overwhelming majority of New Hampshire residents that the appropriate response is simply no response. Thank you for indulging me in that little trip down memory lane. I'd be happy to answer any questions.
Representative Muse.
I noticed that a substantial portion of the bill is reserved for penalties for people under the age of 21. And since part of the purpose of the bill, as I understand it, and part of the purpose of the amendment that the constitutional amendment we considered last week, is to basically decriminalize cannabis consumption. To me, it looks like there's a conflict here, and I just wanted to know, is that something that came up in Vermont? Has that come up in other states that have passed bills like this?
It's certainly been an issue everywhere that's discussed this. What is the appropriate government response to cannabis use by individuals under 21? My memory of this bill, which I haven't really looked at since I was consulted on it when it was being drafted a year and a half ago, or last summer, I thought we were keeping the decrim framework intact. So the decisions that were made in 2017 were that no, we should not criminalize underage persons who possess cannabis. Instead, we should have an appropriate intervention for those individuals. And the framework that we came up with, somebody else could probably explain it better than I have, but my belief is that this bill seeks to maintain that basic balance. And if I'm wrong, I'd be open to an amendment.
Representative Scheer.
In looking at page 2, lines 8 through 10, my reading of this, it says, except as provided, if undertaken by a person 21 years of age or older, the following act shall not be illegal under New Hampshire law, shall not be a criminal or civil offense. So my understanding of what this does is legalize the possession of marijuana for somebody over 21 rather than just decriminalizing it.
I'd say that's correct.
Would you believe that?
I would believe that.
Does it add new penalties that aren't currently in law for people under 21?
Mr. Chairman, I'm looking at page 2, halfway down, beginning on line 21, and this is, as I remember it, this is what's in the decrim statute. So for anybody 18 to 20, they're guilty of a violation and subject to the penalties in paragraph 5, which I don't have in front of me. And for anybody under 18, I believe the procedure is a delinquency petition. So those are non-criminal interventions that were
But it's-
what we figured out in
It's the
2017.
current status of the law. It doesn't add a new penalty, correct?
I believe so.
All right, thank you. Any further questions? Seeing none, thank you for your testimony.
Thank you.
Anyone else? Anyone else wishing to testify on this bill who wasn't done so? I close the public hearing. We're going to take a lunch break. The 12:30 bill will not start until, let me see, 1:15. That's it. We'll be at lunch.
It is now 1:15 and I open the hearing on 12:36 and introduce the sponsor.
My name is Buzz Schur. I'm the prime sponsor of HB 1236. I will refer back to the standard introduction I give this morning, so I don't go through it all again.
Thank you.
So what this bill does is it requires a electronic recording of any custodial interrogation. It's important for this reason. The committee heard a lot of testimony relating to the death penalty, and in that regard heard testimony from one individual who was exonerated after 35 years on death row, and also heard from another person from the Innocence Project. What has been the case, and what the Innocence Project has found around the country over the last 30 plus years that the Innocence Project has been around, or 25 plus years since the Innocence Project has been around, that a number of exonerations involve false confessions. You'll hear some testimony from two people, one from the National Innocence Project, another from the New England Innocence Project, that a surprising percentage of exonerations of people, be it on death row or be it not on death row, be it incarcerated for other reasons, for other crimes, confessed, either pled guilty to the crime that they were convicted of, or confessed when they did not do it. What you see is one study of several years ago, the first, I think, 100 or 200 cases of exoneration by the Innocence Project found that somewhere around 30% of the exonerations that they had developed through post-conviction DNA testing involve false confessions, or people who pled guilty to the crime. The problem essentially is this, and you'll hear more detail about this from other witnesses. The problem is this. What we've seen is that vulnerable people who their first language is not English, or others with developmental or intellectual disability of some sort, are very prone to, for lack of a better word, a pressurized interrogation. And so the focus of this bill is to have a record of a custodial interrogation, starting from Miranda all the way to whenever there's a custodial interrogation, all the way to the completion of the interrogation. One of the advantages to this, is one, it protects from what I've just described again, but it also reduces the number of cases in which, whether Miranda was waived appropriately, whether Miranda was read to the suspect or not, it reduces dramatically the number of those cases filed because it's on record, because the defense attorney can look at the tape and see what the circumstances are. So while there still may be challenges, it's going to be a lot harder to win those when there's a recording. So it is protection for the prosecution of that case, not just protection for the individual against being pressured into interrogation. I don't know what number I'm on. I'll say number 3. You heard testimony from Barbara Keshen and from former Attorney General Phil McLaughlin about the Buchanan case in Hopkinton many years ago in the early to mid 90s. In the Buchanan case, 6-year-old Elizabeth Knapp was found sexually assaulted and murdered in her bed in the home in Hopkinton, where she lived with her mother and her mother's boyfriend. The police interrogated the mother for close to 8 hours. The mother was not, struggled intellectually, was, let's call her a vulnerable person. At the end of that 8 hours, she finally told the police that, yeah, I saw my boyfriend when he went up to bed. We've both been drinking. I waited a while. I went up to bed, and when I went past Elizabeth's room, I saw him on top of Elizabeth. He was arrested and charged. The Attorney General's office, as a former Attorney General McLaughlin said, he was the Attorney General at the time, said, we were in the process of discussing whether to charge him with the death penalty, a death penalty offense, because it was sexual assault in the course of a homicide, or a homicide in the course of a sexual assault, better way to put it. They sent evidentiary samples taken from Elizabeth Knapp down to the FBI for DNA analysis, because at that time New Hampshire did not have a forensic DNA lab, and it took somewhere between 6 and 8 weeks for those results to come back. They were on the verge of charging Mr. Buchanan, Roy Buchanan, with a death penalty offense. The forensic DNA analysis came back. He was not the guy who did it. It was somebody else, who was later prosecuted and found guilty. The bad news, the good news in that case is forensic DNA evidence was available for analysis in that case. But less than 10% of all homicide cases have biological evidence in them that is analyzable with DNA evidence. So 90% of all homicide cases, you can't do forensic DNA analysis, and you're reliant on potentially a confession like the so-called confession, the witness interview. It wasn't the suspect confessing, but a witness interview like the one of Elizabeth Knapp's mother. And that really goes to the core of this legislation. It was a custodial interview of the mother, even though she wasn't a suspect. My understanding from talking with Attorney General McLaughlin and others is that it was a custodial interrogation. That wouldn't have, if it had gotten to litigation, that would have been evidence. I think it's important to understand what kind of difference this makes, particularly in cases when there's not biological evidence available and forensic DNA testing can be done, which is the huge majority of homicide cases, let alone other criminal cases. The standard burglary case, the standard theft case, the standard, credit card fraud case. I mean, the huge majority of cases don't have forensic DNA evidence. Finally, last point, you will hear from witnesses from the police who say, we can't do this, it's too expensive. There's many police departments who don't have a full interrogation room with recording equipment in it. We can't afford to do that. This bill says all statements made by a person during custodial interrogation that are not electronically recorded. Every police department in New Hampshire, even the smallest police department, has recording equipment, be it a burner phone, be it a smartphone, be it a 1999 tape recorder that you can get on Amazon. I went on Amazon to look how much they cost. It's not a great expense. It is very easy to record. Can't tell you the number of cases I worked on back in the 80s, back in, as my daughter says, when dinosaurs still roamed the earth and I was practicing as a criminal defense lawyer. I can't tell you the number of cases where some of the evidence against my client was a recorded confession. Sometimes a recorded confession in the backseat of a police cruiser where my client was in custodial interrogation was being conducted. So this is not a big imposition. It's not expensive. It can be done in a very straightforward, easy way, and it protects the individual. It protects the prosecution of the case from losing evidence because the judge finds that there wasn't a knowing, intelligent, voluntary waiver of Miranda, or there wasn't any waiver of Miranda. It protects the whole system from confessions that might either be false or might be taken under circumstances where Miranda was not violated. So I'm more than welcome to entertain any questions.
Representative?
Thank you, Mr. Chair. Thank you for taking my question, Representative Scheer. Could you highlight that data point again? What percentage of people brought to death row have actually given a false confession?
I don't have the number in terms of death row people, but 90%, 30% of people, at least in a study that was done, I think of the first 200 exonerations that the Innocence Project attained, I think it was somewhere around 30% of those people either falsely confessed to the crime or pled guilty to a crime that they didn't commit.
Got it. Okay. Follow up. And I think you had mentioned that it was circumstances of people who have maybe like a mental disability of sorts. Is there stories or is there precedence of people of sane mind also falsely confessing?
I believe there are.
Okay.
I will defer to somebody from the National Innocence Project who will be testifying.
Okay. And I think I have one more. Okay. And material evidence supersedes confession. So like material evidence is stronger than what they say. We go with the material evidence.
I'll give you the lawyer answer, which is slightly more complicated, but gets to where you are. It's up to the jury what's the strongest evidence. There's nothing in terms of before the jury hears the evidence that decides what's stronger or less strong evidence. So the former gold standard of prosecutions used to be confessions, eyewitness testimony, and forensic evidence. You know, since the Innocence Project started working on cases and other entities started working on cases, confessions have the kind of problem I talked about. It depends. Same with eyewitness identification testimony. And in fact, 5 or 6 years ago, myself working before I became a representative, myself working with the Innocence Project, both the New England and the National Innocence Project, we got legislation passed that put in guidelines for what's the best practices for getting eyewitness identification testimony, doing a lineup. So we've tried to shore that up, and that's been the case since then in New Hampshire. This is the next in line. There have been cases, there was a famous case, Josiah Sutton out of Texas, where he was charged with rape. The victim in the case gave not an absolutely strong ID, but somewhat of a good ID of him as the person who raped her. The evidence was sent to the Harris County DNA lab in the county for Houston. The DNA analyst came back with it's Josiah. Josiah Sutton is a very likely contributor of that DNA sample. He matched the genetic profile. He got a lengthy sentence. 5 years later, an audit was being done of the Harris County Forensic DNA Lab, I think originally for other purposes, but involving the Josiah Sutton case, and the evidence in that forensic evidence in the Josiah Sutton case was analyzed again, and he was acquitted. He was exonerated because the analyst, for whatever reason, screwed up. So there are some cases of that. So what we've learned broadly from the Innocence Project is even those 3 pillars of, gold standard for evidence, confessions, eyewitness identification, forensic evidence, they're not perfect either. And the point of this bill is just a little more protection for everybody.
Any other questions?
Over the years, we've had a number of body cam bills before us, and I know one of the differences between this legislation is the body cam legislation tends to be pretty exhaustive when it comes to defining what happens to the recording after it's made. I notice your bill basically requires that a custodial recording be made, but it doesn't really say what happens to it afterwards. So is there some standard procedure where recordings are handled in evidence that's already in statute?
I haven't checked with every police department in the state, but two answers. One, I get to give more than one answer because I'm a law professor.
Okay.
Two answers. Number one, I can't imagine any police department not preserving that recording because it's great evidence for them. They got, if they're going to use it at trial, the suspect has confessed. So, number one. Number two, the way this statute is written is if they can't produce a recording of the confession of the custodial interrogation at trial, then it's excluded. So it's to their advantage if they I'm not suggesting that they do this because I haven't heard of any circumstance, but if they disappear the recording of let's assume it was a confession, it's not going to be the confession itself. The officer will not be allowed to get on the stand and testify to what the person said. There are some exceptions, as you can lines 10 through 16 identify circumstances in which there's a presumption of inadmissibility, but if you meet the circumstances described in lines 10 through 16, then it still may, what the individual said, even though there's no recording available, may be admissible if you meet those exceptions. So it's not an absolute exclusion. There are exceptions.
Seeing no more questions, thank you. Winnie Lee.
Thank you, Chair. And thank you, members of the committee, for the opportunity to speak to you today about this bill. My name is Winnie Yee. I'm a state policy advocate with the Innocence Project. And we do support this bill, House Bill 1236, because we believe it's really about promoting transparency, protecting liberty, and preventing the tragedy of a wrongful conviction, as Representative Scher spoke to. Just a couple of data points that I wanted to offer that will kind of help contextualize this. Since 1989, there have been over 3,700 known exonerations that have been uncovered. In a quarter of those cases where the individual was exonerated using DNA evidence, we found that coerced false confessions was a contributing factor. So the 33% that Representative Scher spoke to was those initial 250 DNA exonerations. But now that we have more data, we know that this is still a pervasive issue. A false confession was a contributing factor to the wrongful conviction of one of our former clients, Anthony Wright. Despite having an alibi, he was wrongfully convicted of a murder and rape of a 77-year-old woman in Pennsylvania in 1993. Mr. Wright was just 20 years old at the time. Your brains are not fully developed until you're actually like 25 years old. He was put into a prolonged interrogation without his parents, without an attorney, and he was induced into signing a false confession that the police wrote out for him. They threatened him with physical violence if he did not sign that confession, and so he did. And like many innocent people, they do believe in the justice system. They believe that they will be able to clear their name. They just want to get out of that interrogation room and have that opportunity. But as we know, confessions are so compelling that juries, judges, many people do believe in the validity of confessions. But it's important that we then take parameters in place to prevent those false confessions. Mr. Wright always maintained his innocence. He fought for his freedom. He was initially denied DNA testing actually in Pennsylvania because he had falsely confessed, and the judge said, "You falsely confessed. There's no need for DNA testing." And so he litigated that case, and the American Psychology Association ended up weighing in with an amicus brief, and they laid out all the reasons that someone might falsely confess because of those vulnerabilities, because of their age, because they are suggestible, they have previous trauma where they obey, different commands, because of police practices of deception, lying, or those threats of leniency or violence. Eventually, he was able to secure that testing, and he was exonerated after 25 years, and it was really a miracle that biological evidence was preserved for 25 years from the 1990s when DNA testing was not as advanced and being able to be tested much later. And they were able to identify the true culprit who had a long criminal record in that area. Unfortunately, that individual passed away and was never held accountable. And Mr. Wright did lose those 25 years of his life to this wrongful conviction. But his story reminds us that that's why confessions need to be more closely scrutinized. Because it's not just the innocent person, it's the victims, right? It's the culprit, the real assailant being out there, and it's really a criminal safety issue. And so we know now that recording interrogations, it benefits everybody. It serves as a deterrent against coercive techniques, and it prevents a deterrent against the violation of individual liberties. It benefits law enforcement because there is this accurate record. So if there are any frivolous claims of misconduct, we have it on tape. And it also benefits these judges and juries, so they can really have an accurate record as well as they assess the reliability of these statements. Although some law enforcement agencies have previously opposed recording, many of them now support it. So groups like the International Association of Chiefs of Police, the National District Attorneys Association, the APA, CALEA, the accrediting body, they have model policies supporting this. And today, 31 states and the federal government do record interrogations, as well as hundreds of others individual jurisdictions. They are voluntarily doing that. This bill, just to wrap up really quickly, but this bill has been through many iterations in different committees. And we've heard, we've taken feedback from the accrediting commission here in New Hampshire, as well as from different legislators. And we believe this is a much more straightforward, narrow bill. It is 2 paragraphs. As Representative Schur said, we're not trying to make a police officer's job unfeasible. We want to take into account their real lived realities and experiences. We want them to be able to maintain their duties and obligation and also protect due process and the innocent. And so it does only apply to custodial interrogations. There is that presumption of inadmissibility, but they can overcome it if they have a good reason as to why they couldn't record at the time. And we also did do a survey of the top 20 law enforcement agencies in the state to learn more about, are you already recording, right? Because many people have cameras nowadays, there are body cams. And we've heard back so far from 8 agencies that serve over 250,000 Granite Staters. They said that they do already record. They have the audio visual equipment in their interrogation rooms. They don't mandate it right now, but they do strongly encourage their officers to record. And so this bill is really just about making sure that's consistent across the state and best practices are adopted. So thank you.
Thank you for taking my question. Do you know what sort of motivations or incentives there could be for a law enforcement agency to want to induce a false confession?
That's a great question. And we find that, law enforcement agencies are concerned with safety. They want to close a case, right? They want to solve this case for a victim. And so some of this is unintentional. It's inadvertent. The training that they may have received for decades is that you need to be tough with, the person when you're interrogating them. You need to kind of back them into a corner and they'll confess. We're now learning that those sort of techniques are not actually as effective, and there are different sort of techniques out there to build rapport with defendants, and they will actually kind of tell you the truth. But it's really a perfect storm, right? Police wanting to solve this crime, so they might be saying, hey, if you tell us what happened, we'll go for a lesser punishment. We're trying to help you here. That can inadvertently affect somebody who's coming into that interrogation room with their own lived experience of trauma, with authority, wanting to comply, again, believing that I'll have a chance to kind of clear my name later. And unfortunately, the snowball kind of runs and it can end with a wrongful conviction. Thank you. Thank you.
Kate Horgan.
Thank you, Mr. Chair and members of the committee. My name is Kate Horgan. I'm here on behalf of the New Hampshire Association of Counties. The association is opposed to this bill for a couple of reasons. One is that the presumption of inadmissibility is, with the reasonable justification, could create significant litigation issues for counties, delaying things, costing additional resources for your, not only your sheriff's office, your correctional officers, but also your county attorney's offices. Also, I'm sure you all sit on your corrections superintendent subcommittee as members of the county delegation, so you're all very familiar with this. But it would be an unfunded mandate in our opinion. While Representative Scher is correct, buying a tape recorder is not very expensive. You then have to buy tapes for everything and store all those tapes. And that doesn't end. That's additional storage costs. And even if it is electronically, then it's on the cloud. What happens if the cloud is hacked or crashes and you lose all of that information? And we don't think that bill necessarily directly covers every situation that could come up. And we want to make sure also that we have are not discouraging people who are giving voluntary statements. If you have to say to them, oh, I have to record this, they may say, oh, no, I don't want to be on tape. I don't want to be recorded. And there's no option for anyone to opt out of being recorded in this bill. And we think that is of significant concern. I'll conclude my testimony there, but happy to take any questions that the committee has.
Any questions? Enough.
So police officers actually have to collect evidence now, and they have to put it places, and they have to use computers to store evidence and things like that. I'm just having a hard time in this day and age when every single one of us at this table actually has a device in their pocket or on the desk that can be used to record. I'm just having a really hard time understanding why this is such a burden.
Thank you for the question, Representative Muse. And this doesn't just impact law enforcement, it would impact your correctional facilities as well. Also, I don't want to take out my personal phone and record somebody because I can't just email that. My phone is now evidence. I can't just give that over to somebody. Some counties do have it where they have their correctional officers and their law enforcement have a county phone, but that's not necessarily the case for every county. So that would be, if we're going to buy everybody a work phone now, then that's additional costs. That's additional data. And I would remind you all that when you guys make decisions here and then go home to your county budgets, and you're like, why is this so high? You forget because oftentimes you guys leave your county hats at home here, and it's decisions that you make here that are more impacting the county budgets than decisions that the counties are making directly.
Follow up. I would say that in cases that involve people's freedom, especially in serious criminal cases, that person's guilt or innocence might be a little bit more important than a few dollars in the county budget.
Thank you for the question, Representative. And that is a decision for you all to make. It's just my job to let you know the impact of your decisions.
Thank you.
Any other questions? Thank
Great.
you.
Thank you.
Benjamin Magadi. So let me just say this straight up front. If I butcher your name, I'm very sorry.
There's a high bar.
Are we on there? Okay. So, sorry about that. Thank you, Mr. Chairman, and thank you, members of the committee, to be able to listen to me today. My name is Benjamin Agati. I'm a Senior Assistant Attorney General here with the New Hampshire Department of Justice. The Department of Justice takes a neutral position with regards to this particular bill, but feels that it was important enough for me to come down to be able to explain what we see some of the effects of this bill will have. I've been working for the Department of Justice since 2006. Prior to that, worked for the Hillsborough County Attorney's Office for 2 years, and prior to that, worked for the Worcester District Attorney's Office as well. The problems that you see, that we foresee with this bill, it injects into the law a presumption that all law enforcement officers are liars, and that their testimony is then something less trustworthy than any other witness who then takes the stand. That's not how witness credibility is currently determined in the courtroom, on the stand in front of a judge or in front of a jury. And this would impugn a judicial system that's designed to treat all witnesses equally, not more or less than anyone else. From that, there are essentially 4 different things that are at play with this particular bill, the way that it is written. First, again, it throws in a presumption that law enforcement officers, that their testimony is less trustworthy than anyone else. Every trial attorney, defense counsel, prosecutor, judge works incredibly carefully at every single jury selection to ensure that when a juror is picked for a case, that that juror has no biases for or against anyone else. I don't have enough fingers or toes on myself, or probably in this room, to hear the number of times I've heard in a courtroom the question being asked, so, Madam Prospective Juror, with this witness here being a law enforcement officer, and this witness here being a private citizen, and all other things being equal, simply because that person's a law enforcement officer, do you think you might give them just a little bit more credibility than the other witness? And if any prospective juror to that question has said yes, they are bounced from the jury. They will not sit on the jury. There can be no bias for law enforcement on any of our jurors, for any of our jurors that are selected. This particular statute would state essentially and codify the concept that the law enforcement officer's testimony about what they heard somebody say is less trustworthy because it was not recorded, regardless of what the situation and the circumstances were. That all other things being equal, this individual may not speak about what they heard somebody else said simply because they do have a badge, and simply because maybe a recording device didn't work or one that was not available. That is the huge difference that is now codifying that one particular class of particular witnesses would be inherently, through statute, less trustworthy than anybody else on the street. A great example of that would be small business owner. Inside their store, they see that somebody takes an item off the shelves and goes to leave without paying for it. They step near the entrance and say, "I'm sorry, I saw you just take that off the shelf. Why did you do that? What was that about?" That business owner could go ahead and testify and tell a jury and let the jury decide their credibility, whether or not they were telling the truth about what the person said. But an officer in the same situation, who maybe did not have a camera on them, they could get accused in saying that, well, that was custodial, and as a result, you can't testify because your recording device didn't work, because you don't happen to have a department that has recording devices either on your person or at your cruisers. It changes a law enforcement's testimony to something less than an average citizen. It's not equality. And that's the problem, is that witnesses, when they testify, should all be looked at equally. No biases for and no biases against. This statute injects an inherent bias that's assumed against law enforcement if they did not have a recording device on them during a particular interview. The other issues that are present are the terms that are being used. One issue is that the term interrogation is used. There is a difference between an interview and an interrogation. An interview often involves open-ended questions to try to ascertain facts, whereas an interrogation formally has a more formal questioning and a confrontation of witnesses with facts. Frequently, every interaction that may happen between a witness or a defendant, usually at trial or at a hearing with defense counsel, is argued to be an interrogation when maybe it was not. Maybe it was simply an interview. There's no delineation or definition in this particular statute. What's the difference between an interrogation and an interview? And no other space that I could find within the statutes that codifies or defines what an interrogation is. There is a real difference between those words. Words, to quote George Carlin, words matter. And here, there is no definition for that word. And if I can give you a brief example, previous case that I've seen before where when one individual, defense counsel was speaking at a hearing, arguing to the judge that the statements made by their client were custodial. because they had been at the police department for 5 hours. Yes, they left of their own accord. No, they were never placed in handcuffs, but they were in a room. They were questioned for 5 hours. They were not allowed to make a phone call. They were not provided anything other than water to drink, and therefore it was custodial. And that exact same attorney, 3 weeks later, in front of the exact same judge, stated that, well, Your Honor, this other client of mine, this was a custodial investigation. He drove there of his own accord. He was there for an entire hour. The police plied him with soda, pizza, cigarettes, let him keep his phone, and called his mother twice in the middle of this. And that was a custodial interrogation. And the judge, who's now retired, said, weren't you just here a few weeks ago arguing that the other one was a custodial interrogation? And now this is too, for having all the things that you said were not there before? Without terms defining what interrogation is, this term is going to continue to be argued even more, that what is an interrogation versus what is an interview. Also, with regards to the idea of this being a custodial interrogation, custody is something where your cases are not going to drop off, nor will be the less litigation nor more litigation about saying that whether something was custodial or not. Arguments about whether a person was in custody and whether they felt like they were free to leave from a subjective and an objective standpoint are asked every single day on statements about whether or not they are admissible. And those will continue regardless of this particular statute. Finally, there's no provision in this particular statute if the equipment of the recording fails or it's later lost, or in older cases where no recording was possible. There's no provision if the person being interviewed does not consent to being recorded. There's no provision in here if the statement was made out of state in a place where recording was not possible or lawful. There's no provision if the interview happened 10, 20, 30, 40, 50 years ago in some matters that have been presented before our courts. The catch-all provision in there saying that it could be if it is reasonable justification, if there is a reasonable justification, which is in the second part of the statute, talks about not being, it's not what we've heard before in some testimony about it being a good reason. That's not the term that the statute used. The term is reasonable justification. There's nothing in here that explains what that reasonable justification is. If a municipality decides we cannot afford this, does that mean that that is not a reasonable justification to not have a recording equipment? If the individual decided, I don't consent to you recording me, officer, does that mean that then it was unreasonable or reasonable for that officer to not record? Those are not defined. I asked a coworker earlier this morning whether we had any information about an informal surveys of how many different agencies in the state had recording equipment either roadside or on their person. She was able to inform me that there was a survey that had been done of the 246 municipalities and law enforcement agencies. Only 182 responded. Of those, 45% indicated that they had body cameras that were available. 2% said cruiser camera only. 28% said both. And of the respondents, 25% said they had none. They had none with them where they were, or roadside, that they would have to go back, presumably to a station or a troop barracks or somewhere there to be able to do a recording. There's no accounting here for what's going to be happening with those agencies if a recording equipment is not available. And instead of the regular system that's done now, for every witness who testifies, that officer has to get up on the stand and they have to raise their hand and they have to swear to God or under the pains and penalties of perjury. And they will get cross-examined and questioned, as they should. And then their credibility is decided either by the court or by the jury. This, instead, says that that won't happen. Also, if a defendant takes the stand and chooses to testify on their own behalf, and they testify to something completely contradictory to what they told the officer, here, their statement could not even be used to impeach them, as this is written. So because of that, the Department of Justice sees that those are the issues of what will likely arise if this if this bill goes forward in the way that it is currently written. I appreciate your time, and I'm happy to take any questions.
So I have one. So you talked about bias between the defendant, the police officer. Wouldn't this recording remove all of that?
In terms,
Hard facts right there. What was said by whom, and there's no need for somebody to figure out who's telling the truth and who's not, and who is more likely to or who's not likely to. It's right there. I hear some of the other problems that an amendment might fix, but I can't see throwing this all the way out.
I think with regards to that question, sir, I think that you would not get anybody in law enforcement that would disagree, that they would say they would rather have a recording. I can certainly tell you prosecutors, we would rather have a recording that was there. But the idea that if for some reason things don't work or things are not available or it's an older case, that it is automatic exclusion, even if the defendant later on testifies to something completely contradictory. I think that's where the issue comes up. I don't disagree with you, and I don't think any prosecutor would disagree with you either. If there's something on tape, we would love that.
Okay.
Thank you, Mr. Chair. Thank you for taking my question. I'm just curious, with the federal government and 31 other states having policies similar to this in place, do you have any evidence of it leading to these kinds of issues you're discussing elsewhere? Or is this all supposition, I guess?
With regards to that particular question, I don't have any outside or independent expertise of what has gone on in those other jurisdictions with regards to those recordings, how agencies may have changed or what the individual case law has been. And I'm sure that there's a lot of it. Many other states have additional appellate levels of review on their court systems. They may have circuits of appeal before they get to their Supreme Court. And so as a result, there is a multitude of other case law that I'm sure is out there in those. And I'm sorry, I don't have independent knowledge of those.
Thank you for taking my question. Here in New Hampshire, we have something called the Lori List. And one of the reasons we have that is because not every encounter that police have with the public is actually ethical or even legal. I think we operate on the concept that the trust is earned, and we have body cam law in New Hampshire. And one of the things that I was listening to your argument, and I was trying to figure out in my head, if we accepted arguments like the ones that you have put forward here, we would never have a body cam statute. What is the difference in your mind between taping a custodial interrogation and requiring that the actions of police officers when they're enforcing the law also be taped?
I appreciate the question, Representative. I fear maybe I have misspoken then if you feel that my impression is that an interview that's being recorded, whether it's an interview or an interrogation, because again, there's a difference between the two, especially difference with regards to the language. But I would not disagree that a recording is what is preferred, that is, a recording is what people should be striving for if possible, assuming that the person who's being interviewed consents to having a recording, or they have at least been notified of that. I apologize if I've presented myself in a way in terms of the idea that a recording would not be preferable. It absolutely would be preferable. The question I think here, and the way that the statute has operated, is the concept of outright exclusion of whatever the possible statement was for whatever purpose that may be. And for example, if that came to a situation where an officer was speaking with an individual, and in doing that, and in that conversation, the individual said, it made some sort of incriminating statement, and I'll just make one up off the top of my head. I know the light was red when I went through it. I'll make it up. And then later on, that person takes the stand and says, I know that the light was green. This bill would not allow the state to be able to introduce the person's prior statement, a directly contradictory statement. It would not allow the jury to view what the person's statements were to decide their credibility on the stand. And I would say from a standpoint of trying to pursue whatever justice is, it's important to get the information and present it to the jury and let them make the call. The way that this is written here would not allow that in this circumstance.
Follow up? Wouldn't it be better for law enforcement and the defendant if there was a verifiable recording of the exchange?
I don't disagree with you at all about that. I would say yes. I would think that would also make it much easier with regards to judges and juries to be able to make their own conclusion about what had happened and what had not. I think the other issues that I've discussed with the bill are the ones that are present. So I would not disagree with you on that.
Thank you.
Thank you, Mr. Chairman. Thank you for taking my question.
Yes,
This
ma'am.
actually isn't even really specific to the bill, but I'm wondering, I'm hearing certain agencies when they come in to opine on a bill, and as you did, you suggested a number of concerns that you had with the bill, but you said the DOJ is neutral. Why is that? I mean, what is? I remember a time when agencies took a position, and if they came in with a number of concerns, they said, we oppose the bill for all these reasons. I'm noticing that I'm trying to understand the rationale for being neutral on things when our state agencies are clearly either in support or opposed, but say the neutral. Do you know what the rationale is for that, or?
I can't speak necessarily for other members of my office. I would have to defer to them with regards to that. I'm not part of any kind of group that discusses potential legislation. I was informed about this and asked what my thoughts were and whether it was sufficient enough to testify. I think one of the issues that often comes up and that's discussed is whether or not there may be an issue with the bill that would somehow make it unconstitutional, in which case I think the Department of Justice has taken a strong stance on ones that would violate the Constitution. I don't see that there's anything in this bill that would violate the Constitution, so as a result, the Department of Justice might be neutral, but the effects of this may be strong, and hence the reason for my testimony.
This bill is not supposed to go into effect to 2027. So how would that affect any, I guess, any cases prior to that? Because I believe it would not affect it.
I would say, Representative, that without a clear statement as to whether or not it is or isn't retroactive, then that would be a matter that would probably come into litigation in different cases, and that the court would have a discussion about that. If something was stating that this was active starting as the effective date of the passage, then that would clarify it. But I imagine without that, that's something that individual litigants would bring up in front of the court, and the court would then discern whether or not it should be applied retroactively.
Thank you.
No other questions? Thank you.
Thank you very much, everyone.
Cynthia Musso. Yes?
I usually get that wrong myself, so. I have other names. By the way, former student.
I would prefer he not introduce me because I feel like that's going to affect my credibility right from the
Whoa! Oh, yes. Thank you very much.
Goddamn former students. Ungrateful.
I'm Cynthia Musso. I am a staff attorney at the New England Innocence Project, and I previously was a public defender in New Hampshire for about 10 years or so, and a public defender in Massachusetts before that. I want to address, before I get to my testimony, a couple of things that were raised today. And I want to address some of the concerns that have been raised and some of the points that I've made. I think one of the things that have just been highlighted here is the state has sort of agreed that recording is beneficial, I think, to a lot of your concerns, Rep. Muse. And I think one of the things that the state is trying to avoid here is accountability, which is really the piece that recording gives us. The accountability here is the important part. The difference between a police officer being recorded and a small business person being recorded is that police officer is someone that's there to serve the citizens, right? This is a person who holds a public office, you know, a public safety role, not a public office, but a public safety role. This is somebody that we're asking to do work for us. And so we have to have some transparency and some accountability to hold those people responsible for the things that are occurring. We don't ask private citizens to do that because we're not asking them the same responsibility, right? To quote Spider-Man, with great power, right, comes great responsibility. And this is actually very minor. We already have these body cam that are happening body cams record, right? So if we have body cams, we can do recording. If we have cell phones, as Rep. Scheer highlighted, we can do recording. When we maintain that the legal system is infallible, this is dangerous and causes harm to the people that I serve, which are the folks that are incarcerated for things that they didn't do. We don't put these in place because we have doubts about law enforcement. We put these in place because we know that statistically, these are things that are occurring that are leading to wrongful convictions. So we know that I'm not even suggesting that law enforcement had made these false confessions or induced these false confessions knowingly. Often false confessions come about, they're inadvertent on both sides, but we have no ability to assess that as an organization unless we see it, because we don't know all the factors that are at play there. I don't think that people try to elicit false confessions directly for the most part, but I think it occurs very often. One of the experts that we often work with talks about the reason he ended up being a huge advocate for recording is he was a police officer and he inadvertently got a false confession in a case. He realized it was a false confession and then started doing this work to make sure that he was raising awareness around the fact that, like, this happens without intention. You've heard the statistics, and I won't sort of go back over those, but I think it's really important to highlight that the majority of people that will actually benefit from this bill is the police. The small fraction of folks that are going to be, freed from incarceration is admittedly small. But that's so significant. Most of the people that are going to benefit are the police that are going to have, exactly as we've highlighted today, very concrete, very unbiased records of exactly what occurred and how it occurred, so that there will be reduced arguments around suppressing those confessions at trial. I've heard a lot of discussion today about interrogation not being defined by the statute. It doesn't need to be defined by the statute. Custodial interrogation is something that's very common in court. It's defined by case law. It's discussed by case law. Courts are very familiar with it. That's why we didn't define it. It was unnecessary to define it because it's a term that's very well known and understood by case law in this case. I would also point out that another thing that's very clear, and this goes to a concern that was raised about the retroactivity. I think the presumption is that the statute would not be retroactive. So it would be for everything moving forward. That's the presumption. Whether it becomes argued down the line, I mean, I can argue whatever I want, but that's the presumption, and that's the law. That's what the law is, as you pointed out, Rep. All of the highlights that the state made about failing equipment or loss or not possible, those are all things that can be argued under that second paragraph about the presumption being overcome. That presumption paragraph is, we purposely left that broad to account for the different things that can come into play when making these recordings, when starting these recordings, when doing all these recordings. One of the things that's been also discussed today is this concept that recording would sort of, I heard Kate Horgan talk about how the recording would discourage confessions. We have specific studies that is not the case. We have this has been studied. This is one of the very normal areas of false confessions. It is not the case that recording discourages confessions. It is also not the case that, unfortunately, material evidence does not outweigh confessions. This is another study that we have. So unfortunately, if there's a confession in a case, even if there's evidence to the contrary, the jury will accept the confession. These are statistical studies that we have around that specific issue. So the problem with these confessions is they're very dangerous evidence because the juries often accept them even in the face of contrary forensic and physical evidence. So this is one of the reasons that these are so important, because it is such a powerful piece of evidence. As a public defender, one of the things we look for right away in a case is whether there's a confession, because we know that is one of the most important pieces of evidence against your client. Because if somebody confesses, the immediate and automatic thought in your head is, why would you confess to something you did not do? And what we've seen from the cases that we have in this case is there's lots of reasons for that occurring. And I agree that, as many people have said, this often impacts primarily folks that have diminished capacity in many ways. But it also absolutely impacts folks that do not have diminished capacity. I am currently litigating a case where I believe that we have a false confession. The highlights from that case are essentially that the facts of the case itself do not align with the false confession. And this is not a person who has diminished capacity in any way. This is also a person with no criminal record. I'm going to give you just an example. One of the pieces of evidence is that there is a knife wound in the person's back. our client said that he inflicted this knife wound with a 2-inch blade. The wound in his back through ribs is 4 to 5 inches. It's just like physically not possible. But this is what he said during his confession, and this is how we know it's a false confession, because the facts of the case don't align. But the problem is that when he tells these stories and gives details like 2-inch knife, it sounds so convincing to people because he's giving these details, but you don't know where he got those details from. And the reason we don't know where he got those details from is because we do not have a recording of this confession. I don't know where he got 2-inch knife from. All I know is that that's what he said in the written statement that ended up coming out from that case. I think there is so many things. Even if I look at the police manual, just the 2020 police manual, there's a number of listed things that the police have to consider when they're considering Miranda. Poor command of English, being under the influence of alcohol or drugs, diminished mental capacity, mental illness. This is in their own manual. These are all things that they have to assess on the spot when they're making these determinations. That's very difficult. Those are all factors the court has to consider as well. If somebody is testifying about that, it's very easy for defense attorneys to make hay in there, and that is very true, and that is the space that we would do that. If these are recorded, the court can see for itself. There is just not going to be litigation around these because it will be apparent on the video. This just really reduces this and gives this protections here right in place. Those are things that's right in their manual that they have to consider when they're doing interrogations. I think the other piece is that I want to talk a little bit more about the physical material evidence. If we have had recordings of these, we would be able to see a lot of times how these false confessions come into place. So often what happens is people implant ideas, or they'll make promises, or they'll make implied promises, and we don't hear those on the recording. Often there's a technique that's very often used in police interrogations called the Reid technique. This is inherently coercive, and there's a lot of reasons why it's sort of problematic. And it's not because the police are doing it with bad intention. It's because it inherently encourages certain answers to questions. It's like leading questions. We don't use leading questions in court because inevitably it suggests an answer, right? So we shouldn't be suggesting an answer in cases of confessions. This should be something that's free and totally voluntary, not given because you think you're going to get a reward or because you're afraid of some very specific punishment. I think there was a question about evidence preservation. Rep. Muse, I think we talked about this a little bit. There is an evidence preservation statute in addition to some of the things that Rep. Shara talked about. Regarding the destruction of evidence, this would be very minimal to store all of this. You could do it as it is in the cloud. I think one of the issues that Kate Horgan had highlighted was, what if we lose all the info that's in the cloud? That's exactly the problem that all of my clients are facing. We have no info. That's exactly the problem. What happens to the police if the info is lost? They don't go to prison for 25 years for something they didn't do. That's what happens to my clients. Okay, I want to talk a little bit about, we did address a lot of the concerns that were raised when we've sort of tried to file this bill in different forms before. I think this really streamlines a lot of the issues that we've highlighted by making that presumption pretty broad, and making this defined by custodial interrogation. One of the other issues that Kate Horgan highlighted was that this would apply to correctional facilities. It's true that if the correctional facility was going to question somebody about a crime that was committed and then try to enter that into a criminal trial, that would apply. But this doesn't apply in the case of internal hearings before the Department of Corrections. It's very clear that this is inadmissible at any criminal or juvenile delinquency proceeding. Parole hearings and those internal hearings at the prison, D-tickets and stuff, that's not covered by this statute. It's not in here. That doesn't apply in this case. In general, officers don't go in there and question people about crimes that way unless you're a police officer. If they did, it would have to be recorded, and I agree with that. Okay, we've tried to sort of incorporate a lot of the concerns that have been raised, and what I will say is that I do think this is streamlined in a simpler application as a practitioner in this state and as an innocence litigator now. And I really think that this benefits primarily the court system, the police, and also obviously folks that are incarcerated for things that they didn't do. The case that I want to highlight is Gary Sifazari. Gary's exonerated in 2019. He was incarcerated for 35 years for an assault and a murder that he did not commit. And this was based on his brother Michael's confession. In September of 1979, a woman was found dead in her home. She was the great aunt of Gary and Michael, who were brothers. The police had leads, which included another man whose last name is Giroux. His first name is Michael, so I'm not going to use that. It's confusing, but Mr. Giroux. But they never arrested Mr. Giroux at that time. That murder went unresolved and unsolved. And in 1981, Michael Sifazari showed up to the police station and asked to spend the night. The police had often seen Michael because he came there for, he had significant mental health issues, and he would come and ask them to spend the night. He exhibited a lot of strange behaviors that particular night. He signed his name Paul M. Cartney on paperwork, and he appeared visibly confused and wild-eyed. Just 3 months prior, the police had driven Michael to a psychiatric wing of the hospital after he was drinking out of a dog bowl outside of a stranger's home. During that car ride, the police had asked Michael about his aunt's death, and Michael said he had gotten upset with her a few weeks earlier. Remember, this is 1981. She died in 1979. And he had hit her on the head, and he said he hadn't hit her, and then he just said that to appease the police. They knew about his long mental health history. They knew about his current presentation and his strange behavior, but they continued to interrogate him. He gave 5 separate statements to the police that day, eventually stating that he went with his cousin Robert to his aunt's house and hit her with a stick. During the final interrogation, when the officer asked unprompted if Michael meant Gary, our client, and not Robert, Michael said Gary and Robert were there, although he never said that Gary had done any of the actions in furtherance of the murder. I apologize. This last statement was the only statement that linked Gary, our client, to the crime at all. Not one of these statements was signed, and not one of these statements was recorded. The only evidence we have of these interrogations are the unsigned, written out statements and the officer's recollection and testimonies about the interrogations. Do I think those officers intended to frame this person? No, but that's inevitably how it ended up happening. Michael was arrested. He got charged with murder. He had a competency evaluation where he recanted his confession and said he was innocent. The examining psychiatrist recommended he go to a psych hospital, and he was later found to be, quote, acutely mentally ill, unquote, and for a year was deemed incompetent to stand trial. Eventually, he was found competent, and despite his renewed recantation, he was convicted, and he died in prison in 2000. Gary was also arrested. Despite his repeated assertions of innocence, he was convicted in 1984. He was in jail for years until we had DNA testing, which revealed that neither Gary nor Michael was a match to the DNA found at the scene. Instead, the match was the original suspect that the police had, Michael Giroux. Mr. Giroux was dead by the time that this case had occurred. In the meantime, he had gone out and committed additional crimes, including other brutal and physical assaults. One of the lessons that we learned from this case, although Gary was exonerated, he sat again for 35 years, and Michael was never exonerated and died in prison. One of the things that we learned from this case is that recording this interrogation would have been critical evidence. If the jury had seen how ill Michael was, if the jury had understood how much stress he had been under, if they had been able to see the questioning and how that affected Michael, not just Gary's conviction and wrongful conviction, but Michael's too could have been avoided. There have been 0 exonerations in New Hampshire based on false confessions. And although I would love to believe that that's because we have a flawless system, this is simply not supported by national statistics. Instead, the data nationally suggests that we are, in fact, missing some of the wrongful convictions that are here. I am the only full-time practicing innocence attorney in this state. I do the best I can. I cannot reach every case. Recording these interrogations is a small step towards reliability, honesty, accuracy, and transparency. And in a criminal legal system that relies on evidence, only the most accurate and objective evidence should be accepted. We would ask you to pass House Bill 1236.
Any questions? You see none. Thank you.
Thank you.
I got it to my mic.
Thank you, Mr. Chair and committee members. I will be brief.
Thank you.
My name is Matt Amatucci. I'm here with the state police. We too are neutral on this. I know that you don't care for that. We have some concerns, and I just have a couple of brief statements that I'd like to make. Many of the comments were already made, but Not all law enforcement officers are equipped with body cams or the technology to record. The state police is, but there are many agencies, as we heard earlier, that are not. There are instances when law enforcement make arrests and Mirandize roadside and ask questions, such as DWIs. And again, if they're not equipped, those statements would not be admissible. It's always best practice to record, but it's not always practical. So recording custodial interrogations is a powerful safeguard for justice, but real-world conditions sometimes necessitate reasonable exceptions like emergencies, equipment issues, or suspect requests, as stated previously. So with that, I'd be glad to answer any questions that the committee may have.
So let me get this right. So if that police department doesn't have the ability to record on the side of the road, that officer can't testify on what was said in court?
So with this proposed bill,
That's wrong.
if that person is placed into custody and questions, incriminating questions, that would be a custodial interrogation by definition. Those statements would not be admissible if not recorded.
I know I can't ask the witness questions.
Yep.
I would suggest to the chair that that might well, two things. One, that might well be a circumstance covered by the exceptions built into the second paragraph of the bill. And number two, my experience is that any custodial interrogation in DWI cases most often occurs at the police station. The person isn't taken into custody. The police can do a lot of questioning at the scene of a DWI that is not custodial because they haven't been arrested yet. And most police officers I've talked to wait to take the person into custody so they don't have to Mirandize them and they can ask a lot of questions. That's what usually happens on the roadside.
My suggestion is we look at that and make sure we get that fixed.
Yep.
Any other questions? Thank you.
Thank you.
Anybody else wishing to testify? I close the hearing on 12:36 and open the hearing on 12:37. That's what I thought, but I wanted to make sure because.
One of Terry's.
Huh?
It's one of Terry's.
We're gonna, there's an amendment coming, so we're gonna recess till next week for this. Yep. And I'm closing the hearing and opening, 12:39. 38. Oh, yeah.
And that's also Terry's.
That's also Terry's, but we don't have to recess it. Who else is on that?
The Boyd, LaSalle, Paquette, you're on the.
Yep. So you didn't get out of it. Oh, yeah, the next one says.
Good. I'm Kathleen Paquette. I represent Hillsborough 25 Manchester, and I'm not prime sponsor on this bill, but I'm introducing it. This bill prohibits certain registered offenders who are required to register due to a sexual offense against a child under 13 years of age,
the
appearing
right one?
within.
No?
Nope. 12:38.
Scrap that. Yeah, I know. That's what I thought.
Nope. Man. Whoa. Yeah, take a minute. We're usually not this disorganized.
Okay, I'm still Kathleen Paquette from Hillsborough 25 Manchester, and I'm still not prime sponsor on this one either. But what this bill does, it amends penalties for the offense of disobeying an officer. And this bill was created as a result of, as a request of the Department of Safety. I do know that this is one that I've actually had conversations with from Manchester Police, and the response to this when I talked to them about it was, thank God. Other than that, it basically increases penalties for disobeying an officer.
Excellent. Any questions? Seeing none?
Oh, I can't resist.
So close.
What are the, and you may not be able to answer this, and if so,
Probably not.
I'll ask, assuming officers can testify. But what are the provisions of paragraph 1, 265, 4, 2, and 3? Is it anytime anyone disobeys a police officer? Or is it in certain specific circumstances? It says any person who violates the provisions of subparagraph 1, A, B, C, D, E, or F. I don't have those in front of me. Would you happen to know what they are?
I do not. Yep.
Driving a car.
Yeah, they're
Okay. Thank you, Representative Muse. You want?
Any other questions? Seeing none, thank you. Cap? Hopefully you can shed some light.
Thank you, Mr. Chair and committee members. Again, my name is Matt Amatucci with the New Hampshire State Police. We're here in support of this bill. This legislation strengthens the penalties for individuals who disobey a law enforcement officer and flee during a motor vehicle pursuit. It updates RSA 265-4 to classify fleeing from an officer under subparagraph 1C as a Class B felony and elevates penalties to a Class A felony when such actions result in injury or death. These changes reflect the seriousness of the offense and the danger it poses to the public and law enforcement. The New Hampshire State Police has seen a 123% increase in pursuits since 2017. This trend underscores the urgent need for stronger deterrence. Pursuits are inherently dangerous, not only for the officers involved, but for the innocent citizens who share New Hampshire roads. High-speed pursuits lead to the severe crashes, injuries, and fatalities, creating unnecessary risk for everyone involved. This establishes clear, elevated penalties based on the severity of the outcome. Class B felony for fleeing from an officer, Class A felony if the pursuit results in injury or death. Maintain license suspension provisions to prevent repeated offenses. It sends a strong message to the fleeing from law enforcement will not be tolerated in New Hampshire. We have worked closely with stakeholders, including law enforcement agencies, public safety advocates, and legal experts, and we all agree that this is a best practice bill that fills a long-standing gap in our law. By enacting these changes, we create a strong deterrent to reduce pursuits, protecting the lives of New Hampshire citizens, and safeguards the officers who risk their lives in these dangerous situations. This bill is about saving lives and reducing unnecessary danger on our roads. Stronger penalties will help prevent pursuits before they start, making our communities safer. So with that, open up to any questions.
Representative?
Thank you, Mr. Chairman. Thank you for taking my question. Would this also include foot pursuits or just in automobiles? Because it looks like it doesn't specify.
Thank you for the question. This is involving motor vehicle pursuits.
Any other questions? Seeing none. Thank you. Oh, Chris? Oh, go ahead.
Just thinking, I just wanted to respond to the representative. It's disobeying an officer. I'm looking at the statute. No person while driving or in charge of a vehicle shall, and then it has the list. So it doesn't seem to be just in terms of pursuit. Although I know there's a number of bills because I'm a co-sponsor of one of them. I certainly support that idea because I think the level of dangerousness is out of hand and we have to do something. But I think this is bigger than just that. I think this addresses a refusal to give your name, date of birth, neglecting to stop, etc., refusing to sign your name in the presence of an officer, producing your license.
Yeah.
So
I get it.
it's a lot of things beyond just the and I know there's a Senate bill and there's another House bill with the similar intent.
So thank you for that question. And just for clarification, this deals strictly with fleeing from the police in a motor vehicle. It shouldn't include the portion of providing a false name, which is also, that's a misdemeanor, disobeying. But for this, it's just fleeing from the police.
Representative Shear.
It just, in the language she read, talked about in a motor vehicle or in charge of a motor vehicle. So you stop somebody, they get out of their car and run away. You don't intend that this apply to that person?
No, sir.
Thank you.
Any other questions? Seeing none. Thank you.
Thank you, sir.
Anybody else wish to speak on this bill? I will close the hearing on 238 and open the hearing on 239. Representative Paquette, would you like to introduce this? Yeah, I gave you a 2-minute warning.
Hey, my name is Kathleen Paquette. I'm from Hillsborough 25 Manchester, and I'm also not the prime sponsor on this bill, but I'm here to introduce it. This bill prohibits certain registered offenders who are required to register due to a sexual offense against a child under 13 years of age from appearing within 1,000 feet of certain locations under circumstances that would warrant alarm. This bill was also requested by Department of Safety.
Seeing none, thank you. Molly Tremblay.
Good afternoon, everybody. I'm Molly Tremblay. I am a child care director in Claremont, New Hampshire. So this bill, a lot of people are very shocked that we are not covered under what a public school would be. As a child care center, we're not covered under the same rules that they have. And in Claremont, I have been going through this issue, and others across the state have been going through this issue where we have sex offenders who will stand outside, they will look in our windows, they will take pictures, they will just stare at our children, and it's just not okay. Like, it's not safe for these children. It's not fair to my staff to have to be studying the sex offender registry to just check on people who are just walking by, and it scares these children. It scares my staff. And when we're on high alert because we're out looking, these kids feel it. And that's our number one priority, is that these children who have already been through so much. I have a lot of children who are in protected custody, DCIF custody, or they've been through traumatic backgrounds, a lot of circumstances, and they've already gone through so much. But when we're calling on our police department, they're telling us that there is nothing they can do, because technically what this offender is doing is not against the law. They are allowed to stand there and stare or take pictures. And with this bill, if we were able to pass this bill, that would not be allowed, and we would be able to call the police department and they would be able to move this person along, and not only just move the person along, but actually make it so that they are held accountable for what they are doing. So thank you for considering this bill, and please help us keep children safe.
Just a quick question. They can't use the trespassing law to get them?
I am not certain, but I can tell you in certain circumstances. So I've had an offender who will stand across the street from our center, and we'll call the police department. They'll come, tell him, move along. And 20 minutes later, he comes back.
In general, I support this legislation. My concern is, I know you don't have it in front of me, so I'll read it. Warrant alarm for the safety of persons in the vicinity of paragraph D says, any area where a reasonable person would know that minor children congregate. Does that seem like, I live in Portsmouth. I'm trying to think of an area that is within 1,000 feet that is that where children don't, that's within 1,000 feet of where children don't congregate. And my concern isn't with A, B, and C, which are any child care facility, any church, any school, but that very broad language. Would you have any difficulty if we got rid of that last very broad language, because it seems to cover, in a small town like Portsmouth, geographically, like the whole town? Would you have any problem if we modified or got rid of that particular paragraph?
I wouldn't personally. I do believe, though, that the bill is about loitering or prowling, so it would have to be they are warranting alarm rather than just passing by or like walking their dog in the park.
And follow up, and I get that. It's just there's a lot of places within 1,000 feet of like a park, like downtown Portsmouth has a Prescott Park and some other areas where there's a lot of houses in between that park and the 1,000 feet limit. So that's my concern, and I'll leave it at that. I'll bring it up at executive session.
Representative LaSalle.
In deference to the good professor, if you look at line 5 and 6, it says 1,000 feet of any of the following places under circumstances that warrant alarm for the safety of persons in the vicinity. So I read that if somebody is within 1,000 feet, but they're not doing anything wrong, they're just walking along a sidewalk or something, then they're not fitting that category.
And I tend to agree with you. My concern is that somebody tells somebody who's at the park that, yeah, there's this guy who lives in a house 1,000 feet from the park. You can't see it from here.
So I see that differently. So, knowing appears in any of the following places under circumstances, and I believe it's like the child care facility, church, school.
Yep. I have no
1,000
problem with
feet
those.
from those, the following places, not just. Oh, I see the other one.
We can talk more
Or-
about this
or-
at executive session.
Yeah, I almost wouldn't even include a park because other people, not just children.
But it is
But
it is
I
a
get
place where
that.
people congregate. children congregate.
I get you. Oh, sorry.
I apologize. When I look at this, and when you mentioned the church, did you have any conversations with churches before adding this to this bill?
I didn't write the
Okay,
motion.
oh, that's right.
No.
You didn't. I'm sorry. You're just giving a testimony. I'm sorry. You're right.
So did that.
I know who to ask.
So churches
question.
usually have schools in them.
Exactly.
So
Exactly. But then also they have other programs within the church.
Right.
Most of the churches,
Yeah.
especially in Nashua. And these type of people would probably be there. To be honest
Correct.
with you.
So that's
So
why
I'm
I-
just struggling with what I'm reading. That's all.
Yep.
Okay.
I think we can work
I
this
think-
out in
Yeah.
executive session.
Any other questions? Seeing none? Thank you.
Thank you.
Corville?
Yeah.
Jackie Corville? Yes?
Good afternoon. How do you do?
Very good.
My name, Chairman Roy and members of the committee, I'm Jackie Cowell from Early Learning New Hampshire. And we are a statewide nonprofit that works with childcare programs to support their work as well as the families they serve. And so I just wanted to, first of all, thank so many members of the committee who are prime or co-sponsors on this bill. I appreciate that. This particular concern came out. We help convene a Zoom call twice a month with over 100 childcare providers on it, and this came up as a concern. And so Molly and Linda Tremblay from Ready Set Grow in Claremont and a few others went over to the Department of Safety and met with Associate Commissioner Edwards and with Commissioner Quinn and talked about the concern. And so that's where this bill sprouted from. And so we are in support of this bill because, as Molly said, there have been programs that have continually had folks sitting around causing alarm, causing worry, and there's nothing their police department said they could do. So that's how this bill was built. And so I support this bill, and thank you.
Thank you. Representative Sheard?
I'm sorry. You've heard our discussion about paragraph D.
Yes.
Again, I'm in full support of A, B, and C with maybe some tweaking of earlier language, but do you have any sense of, any thoughts on what we've discussed about paragraph D?
Yeah, when we were asked that question, I understood your concern. I think I would want to know from the Department of Safety, who helped craft the bill, why they put that in there before I'd answer that just patently yes or no.
Thank you.
Sure.
Seeing no more questions, thank you very much.
Thank you.
Lieutenant?
Good afternoon, Mr. Chairman and committee. I work for the New Hampshire State Police. I oversee records information services, which actually includes a sex offender registry as well. And I know they get a lot of calls on individuals being in certain places, and there's nothing really in law for sex offenders not being able to be in certain places. Along with the child care, like they said, they came to the Department of Safety in order to kind of discuss where this could sit and where could it fall that would make sense into a law. So when they looked at it, this is where it kind of fit best, was in the loitering prowling. And the idea was, when we said it had to cause alarm, was to say you might have a parent that has a kid and you're going to be at that school watching your kid. So that's not something that's causing alarm. It's something where they are just sitting outside a daycare center. I know we talked about the park a lot, and I think if you are sitting at a playground watching these kids with no other purpose really to be there other than to sit there and watch kids, is where that playground comes into play versus walking through the park or walking your dog through the park. I think that alarm has to be there, and I think that's something that has to be proven in order to say that person is violating this law.
Sure.
And I get that, and I support the idea behind that. My concern is somebody who's a registered sex offender under tier 2 or tier 3, who lives within 1,000 feet of a park, that the parents who congregate at the park with their kids know that that person lives within 1,000 feet, that would cause them alarm, and the person's within 1,000 feet. And my guess is that's not what's intended by this language. So would you be supportive of some tightening up of that language to account for that
I think
circumstance?
maybe saying being in that area with no legitimate purpose. If the, you know, so if you're living 1,000 feet, your legitimate purpose is you are living in that home versus just sitting outside of a playground. So it's hard to cover every place a kid would be at, but the idea is time to protect the children and make sure, and that alarm has to be proven, like I said earlier. So if you're at your home, that would be a tough thing to prove, to say someone's living in their home, or they're at a basketball game because their child is playing on that basketball team. Well, they're going to be there with those children because they have a legitimate purpose to be at that basketball game watching their own child.
Yeah, maybe we can work with that language.
I think so, because he has to be causing alarm, not just because the parents know he's a sex offender, but because he's doing some action.
In that particular circumstance, at that moment on that day.
Right.
Yeah.
Just living in that 1,000 feet shouldn't be causing alarm, right? He's home doing his stuff. He gets out, walks to work, walks back. That's not an alarm. But if he goes, stands in the park and doing his thing with his camera, that's an alarm.
And I agree with that, and I think we can fix that.
Any other questions? Yep.
Excuse me. Thanks for taking my question. There was a situation last year where there was a very highly publicized case of a high school person who was transgender. And it so happened that the father of that person was a sex offender. And some of the parents, of course, it got blown up because of the whole kerfuffle about transgender, but a lot of the parents didn't like the fact that this guy was taking pictures of the high school soccer players. Would this bill impact that? He did have a child who was playing, but he was a sex offender. I don't know if that impacts it or not.
That's a good question. I think it would have to be looked into as a whole. I think if you're taking pictures of your own child playing soccer and that's what you're really focused on, then no. If you're taking pictures of other kids, that could be more of a issue.
Thank you.
Thank you.
Any other questions?
Thank you.
Anybody else wish to testify? Seeing none, I'm going to close the hearing on 12:39. Open the hearing on 12:40.
I want to compliment the chair on catching up on my other prior chairs.
You know what I learned today? I'm going to put a 2-minute time limit for lawyers.
Thank God I'm a law professor.
You don't have to know about stuff. Just read the little summary.
You want me to do it? Mark, I'm a co-sponsor on this. You want me to do it?
Yeah. Go for it.
Don't mind.
Go for it. Let's not like the other way. I was gonna say, what's a lieutenant? Yeah.
Just the way it sounds.
Caterpillar. CATABROKER.
Thank you, Chairman Prue and members of the committee. My name is Rich Lascelles. I represent Hillsborough 14, the town of Litchfield. I'm here to introduce House Bill 1240 FN. It makes it a Class B felony to violate certain provisions of the criminal threatening statute while using what reasonably appears to be the victim to be a deadly weapon. And I will not be taking questions.
Thank you. Anybody want to speak to this bill? Seeing none? And a nice job you've taken this.
You could have taken longer because.
Yeah.
All right. Our next hearing will be in 10 minutes or 9 minutes. So I just sent them. Okay.
Because they're all of them. It's like.
I'm fading fast. Okay, thank you. Yeah, I'm gonna leave pretty soon. Yeah.
I think I can make it. hearing on 1244.
Thank you, Mr. Chair, members of the committee. State Representative Matt Saborn Jr. from Rockingham 30 Seabrook, introducing on behalf of the prime sponsor, HB 1244. Prime sponsor is Representative Farrington. I know he stopped by and spoke with us about this bill. This bill is about relative to exceptions to the charge of criminal threatening, and I have a statement he would like me to read out, and I shall do that. This bill makes a slight change to RSA 631-4, the criminal threatening statute. Right now, an exception exists for displaying a firearm if it is reasonably believed that a threat exists which would cause serious bodily harm or death. This bill broadens the exception for displaying a firearm by including a response to someone who is perceived to cause property damage or who is criminally trespassing. This bill was brought forward after the McCloskey couple faced unfair prosecution for defending their property in St. Louis during the BLM riots. They lived in a gated private community near the home of the city's mayor. In June of 2020, a mob violently broke into the gated community and marched towards the mayor's house. The McCloskeys came outside displaying their firearms to deter the mob that was criminally trespassing from destroying their own property. They later faced prosecution for defending the property. Individuals have a natural right to defend and protect their own property. Strengthening this existing statute will ensure that unfair prosecution will be prevented in New Hampshire. Thank you for your time. Being that I'm not the prime, I'm not ready to answer questions. I think we do have some other folks who are here today to take questions, but I can open the floor.
Let me ask this question.
He can't help himself, so he's got to ride it out.
It's genetic proposition. He wants no part of you, is what I'm hearing. Are you aware in the McCloskey situation, not only did they wave firearms, but they said things too? You aware of that?
That's very believable, yes.
And this statute doesn't apply if not only they display a firearm, but they also say words. This goes back to our conversation of yesterday.
You can't say words?
That's quite interesting.
No, under this statute, you're only quote unquote protected if you just display. But if you display and say words like, you better not come on my property or else.
I can't say, please leave my property?
You can say, well, that's an interesting question because as one of the people testified yesterday, the question then becomes, is the person who is criminally trespassing, when you display the firearm and say, get off my property, is that person now in fear of serious bodily injury? If so,
God, I would hope not.
If so, it may well be that you would be chargeable for criminal threatening because of your words, because they've been put in fear because of your words. So as I read this statute, it was designed, according to Representative McFarland, it was designed only for the display as long as there's no accompanying words that might reasonably be interpreted as.
I know I shouldn't go down this rabbit hole, but I'm going.
I can't. I know I'd provoke you. I'm good at provoking.
So my gun doesn't put him in fear of his life, but me telling him to get off my property puts him in fear.
Well, it depends on how you. It depends on how you.
Any sense,
Representative Prue, it depends on how you phrase it. If you say, wielding your gun up here, you say, you better get off my property. That's more threatening than the other extreme. Gun, please get off my property. The difference between those two is for the judge to decide whether it's criminal threatening on your part.
Okay. Any other questions for the representative? I would think not. Thank you for introducing the bill. Cap? Pretty good. There was a carrot at the bottom.
Thank you, Mr. Chair, committee members. My name is Matt Amatucci with the State Police. I've thought quite a bit about this in the conversations we had yesterday. I'll make a couple of comments and then we can have further conversations if you would like. The threat of deadly force during non-deadly force scenarios could result in greater number of negligent homicides. Explaining or expanding firearm access under legislation could heighten these risks, creating scenarios where individuals brandish firearms during non-deadly force situations. And that's the question at hand, is you're introducing a firearm during non-deadly force situations, and the question becomes, what if that person acts? So if you brandish a firearm during a non-deadly force scenario, and that person is not warned away, then what? If that person takes steps toward you and advances toward you, then what? Because it is not a deadly force situation, but you now have brandished a firearm. The question becomes, what does that person do? And there's two scenarios that can occur, and it can drastically influence two lives. Number one, the person shoots the person as they advance toward them, not justified. One person loses their life, and the second is looking at going to state prison for a negligent homicide because they felt in fear, but it doesn't elevate to a deadly force situation. So that's the question for the committee to determine, is this what we want to have as far as statute? Do we want to have exceptions where you can display a firearm, which is deadly force, in non-deadly force scenarios and potentially create a deadly force scenario?
So I know I've heard a lot of situations where it is starting to progress to the threshold of deadly force, but the mere fact that I went like this, people, he has one too, I'm leaving, I'm out, because I don't want to get in this confrontation. I hear that stops more of those events than escalates them. And again, wild card, I know some people will just escalate, but most people will run away. But that's just my kind of thought on that. Representative Scheer.
Yeah, I understand what the interim chair is saying. My concern is by passing a statute like this, or a more aggravated version of this, the bill yesterday, which had a lot more things than just criminal trespass, is we start going down the slippery slope of what I call escalator statutes, that it just embeds the risk of escalation rather than de-escalation. And particularly in the circumstance of criminal trespass, it's one thing if the person who decides to display the gun is confronted with the way the statute reads right now, which is the risk of serious bodily injury or death. I mean, it's one thing to display the gun there, and I get that, and I'm in support of that statute. But when we start talking about, in this case, criminal trespass, which itself is a misdemeanor, assuming that it's well posted and there's a warning, or property damage or theft or things, my concern, would you agree that there's a bigger risk of unintended bad things happening by having this kind of language?
Yes, thank you for the question. I would agree with that. It could escalate quickly, and there are endless unintended consequences that could come from situations like that.
For lack of a better way, because people are stupid.
Any other questions?
Thank you for taking my question. Many states have stand your ground laws. I assume that we do not have a stand your ground law. Is that correct?
As far as, like, do you have to retreat from your property?
Yes. If you feel,
No, stand your ground is you don't have to retreat.
yeah, you
Right.
do not have to retreat. You can protect your property. I assume, I'm not an expert on it, but I assume that it's under particular circumstances. But let's say someone is breaking into your home. They aren't in your home yet, but they are breaking into your home. Can you use, what are the statutes in shooting that person through the window, for instance?
Thank you for the question. You still have to be justified in your use of force, whatever that level is. If you're in fear for your life or you're defending a third person, like your family, in what you perceive to be the imminent use of deadly force, then you would be justified in using deadly force.
Follow up, Mr. Chairman?
Follow up.
But simply somebody breaking in would not constitute fear for your life.
Not necessarily.
Thank you.
Yes.
At my house.
In response, just to the extent I'm familiar with this area, the trooper is right about what he said. It changes dramatically if you're not inside your house. Even if you're outside on your property, there is language about, do you have the opportunity to retreat safely? So and if you're not on your property, let alone in your house, if you're just out in public, you have even greater responsibility if you can retreat safely, even if confronted with deadly force. So it's the classic lawyer answer, it depends.
You almost went to the 2-minute limit, just saying. Any other questions? Thank you.
All right. Thank you, sir.
Anyone else? I will close the hearing on 12:44 and we'll be back at 3:30. And the sign will already be changed. introduce his bill.
Dear Chair Prue, for the record, Yuri Polozov, May Mark 10, representing Hooksett and Dunbarton. I'm here to introduce House Bill 1279 relative to the use of physical force in defense of a person. As you can see, it is one of the shortest bills. It adds just a few words in 2 lines of RSA 627:4 Roman numeral 2 D. The bill has 2 goals. They might be addressed separately, but I would love for the committee to support both. First, it adds third person to the definition of those you are allowed to protect in your dwelling. Second, it adds vehicle to the definition of places where you are allowed to defend yourself against a felony being committed. These changes help the bill follow the spirit of our Constitution and the statute. Proposed language will help avoid potential illogical court rulings. Why are these corrections needed? One might argue they are already in the statute. But let's compare this language in Roman numeral 2D with other lists in this chapter. Both Roman numeral 2A and Roman numeral 3 include wording or a third person. So in court, a situation under Roman numeral 2D that involves stopping a threat to a third person could be argued as intentionally outside the statute's protection. For example, imagine I used deadly force to stop a gang that broke into my house with my underage kids and tried to kidnap them. Under the current language, that would be unjustifiable if I am not being kidnapped myself yet. The second part of the bill is similar. If we compare the wording in the lists in Roman numeral 2D to the list in Roman numeral 3, we can see that Roman numeral 3A says, within his or her dwelling, its curtilage, or anywhere he or she has a right to be. Anywhere he or she has a right to be. We spend a lot of time in our vehicles, and we have a right to be there in our vehicles, and our constituents should not be attacked in their vehicles. They should not be found guilty after being attacked first. In the past, that happened in Manchester NH when agitators targeted a vehicle over political differences. Thank you, Mr. Chair. I can try to answer questions, but I'm not a law professor, so I don't know all the details.
Ooh. Ouch. Nice. Any questions? Whoa. Representative Gathright? Mike? I'm gonna put a sign on your laptop. Mike.
I know. I'm just curious. Did something occur that you wanted to put the third person on this?
Yeah. As I said, and as you heard in discussions of previous bill, sometimes it's not clear cut when it's just a felony being committed, for example, against your family member, and when it raises to a threshold of Roman numeral A, when it's when it talks about sorry, I cannot read right now, but about imminent deadly threat. So for this reason, I think that definition of third person needed to be added to this section, Roman numeral 2D as well.
Representative Moose?
In the Manchester situation that you mentioned that motivated the bill, would it have been a better outcome, in your opinion, for the driver of the vehicle to have shot the agitators, given the fact that I haven't heard much of anything about that incident since that time, and I would assume that the law took care of whatever needed to be taken care of without people being shot?
Thank you for your question. So that's just one example why this bill might be needed. Probably even not the best example, but a better example would be some attempt to steal your vehicle or otherwise injure or attack you in your vehicle. So I think it's important to be. But another important point that in Manchester situation, nobody was shot. So situation pretty much resolved itself. But then there was legal action against people who were attacked in their vehicle, and they were convicted basically because at some point the firearm was displayed but nobody was shot. So again, towards the discussion of previous bills we had today, but definitely I don't want more people dead, but sometimes we need to allow people to defend themselves.
Follow up? Your bill authorizes use of deadly force, not just display of the weapon, correct?
Yes, correct.
Thank you.
Anyone else? Oh,
I just have a question, hoping to clarify a little bit. So what you're saying is a good example would be if, like a carjacking. So if somebody tried to carjack and there was kids in the car, like in car seats, is that an example of what we're talking about here?
I believe so, but again, I'm not a lawyer, so I don't know all the definitions that would include in definition of specifically felony.
Thank you.
So, and as a committee, you can put additional additional guardrails if you want only specific kinds of felonies being applied here.
any other questions? Seeing none. Bessie, did you want to testify?
Okay.
I close the hearing on 1279. I know you're disappointed, but we're gonna be out of here early.
That's when there's yet another note though, but Representative Floyd be the one who
Ooh.
I think we should share the wealth.
Which includes motivated by the political stickers on the car, but he didn't end up pressing charges.